Good afternoon, everybody. My name is Brendan Roach, and I'm a research fellow at the Future Society, a nonprofit organization dedicated to the governance of emerging technologies, such as artificial intelligence, for social good. Incubated at the Harvard Kennedy School of Government, the Future Society's mission is to help build a future that preserves humanity while harnessing the upsides of technology. Its activities include policy research, convenings, and educational programs, and the organization has worked with clients across the world, from Cambridge to China. Our Science, Law, and Society initiative has been at the forefront of emerging discussions on ethics at the intersection of artificial intelligence, law, and society, the topic of today's panel. We're pleased to present today's panel on legal ethics in the age of artificial intelligence. Our panelists will be the Honorable Joy Flowers Conti, Chief District Judge for the Western District of Pennsylvania, Mr. Economou, Chief Executive Officer of H5 and Chair of the Science, Law, and Society Initiative, Anthony Davis, Partner at Hinshaw & Culbertson, Amy Mushawar, Partner at Davis, Wright, Tremaine, and Ms. Julie Brickell, Executive Managing Director and General Counsel of H5. Our moderator will be Professor Arthur Miller, whom lawyers everywhere know as the author of the legendary treatise on civil procedure. What you may not be aware of is his prescient 1970 book, The Assault on Privacy, that foreshadowed many of the issues raised by the deployment of artificial intelligence in all realms of society. Please join me in welcoming our panelists to the stage. Thank you.
Thank you, Brendan. Nice to see you all here. I'm an old fogey. I grew up in the world of carbon paper and thermofax. For me, a high-tech day is when I go into class and I have to use the blackboard and a piece of chalk. Yet, no matter where I go, I keep hearing about artificial intelligence, which I think is sort of what my students have. This morning's Times had an article about, I guess it's China is going to create a hospital with artificial intelligence. Even though I wrote a book on computers and privacy, oh, gee, I guess, Brendan, it's now 50 years ago, right? No, I'm like from the Ice Age. Nicolas, what the hell is artificial intelligence?
Well, it reminds me a bit of the debates over the gender of angels. I don't think there is an answer, and I don't think the answer makes much of a practical difference, but I just would probably hit on 3 points. The first one is that there is no settled definition of AI, and in part the reason for that is that there isn't a settled definition of what intelligence is, in spite of 2,000 years of philosophical debates and more.
There isn't a settled definition about what is due process either.
There you go. So I think we can stay with the definition of the person who coined the term artificial intelligence, John McCarthy in 1956, who said that it was the science and engineering of intelligent machines. The one amendment I would have the hubris of making to that definition is to replace the word machines with systems, to acknowledge that, make room for human intelligence in the continuum. And most of the artificial intelligence systems you see today are sort of an interwoven continuum of AI and HI, artificial and human intelligence. So I think that's a broadly encompassing definition that serves the purposes of innovation well. The second point I'd like to make is that the definition really doesn't matter much. I mean, if your rights or your freedom of opportunity or your health is denied to you because of an algorithm, sort of the definitional subtleties really don't matter to you. But I think the most important point is that, and the far more interesting question, is what artificial intelligence is not. And that's much more interesting than what it is. Artificial intelligence doesn't have sentiments. Artificial intelligence doesn't have a sense of right or wrong. Artificial intelligence can't bond with siblings and children and mates. Artificial intelligence doesn't dream about its future when it's awake or about its childhood when it's asleep. In fact, it can't experience what being awake or being asleep is. It has no consciousness. So it's really important to remember that artificial intelligence is not one thing. It's not artificial humanity, and that has, I think, significant implications in the discussion we have today.
Now, Anthony, you're a real person. You practice law.
Thank you.
Does anything that Nicolas just said have any bearing on the practice of law?
It does. Can we go to slide 9? There are 5 areas, as you can see on the screen, where it is hugely impacting the way law is practiced. And I think the first thing to be said about all of these areas is that this is very largely client-driven. Let's very quickly go through the 5, and I'll give you one example from one of them to point to what the significance is. Legal research. Many clients are using non-law firms, often publishing companies and other companies with huge databases, and people who may or may not be lawyers working them to do their legal research without ever going to the law firms they used to consult, because they get faster and more accurate and more useful results from those companies. Expertise automation, those are the programs some of you may have seen. They're almost always in specialist areas where clients have repetitive questions, and the software basically allows the client to go straight into the firm's software and work through the questions to get to its answers. And only at the very end, if they haven't got their questions answered already by the software, do they need to go to somebody who can apply the qualities that Nicolas referred to. Analytics and prediction, very interesting. 2 kinds of prediction we should talk about. A lot of clients are now developing their own, and there are some proprietary ones out there, which allow clients, mostly corporations obviously, to compare results, cost, and speed of outcome among the firms they use. So you're seeing clients saying, well, we use these 3 firms on this panel for this kind of work. Firm A does it faster, firm B does it cheaper, and firm C does it better. But now again, you need somebody to make a decision. The other kind of analytics, which is very interesting and starting to come in some specialized areas, is there are analytic tools that, if you put in the facts and the nature of a dispute, will predict outcomes. They will do it by the nature of the dispute, and with all respect to the judge, they will do it with respect to decisions of the individual judges. They will do it in relation to who the opposing counsel are. Very sophisticated analytics, obviously enabling clients to make decisions about whether to proceed with a litigation and when to stop. Electronic discovery is probably the one people know. And I think Amy's going to talk about the problem of figuring out which companies are good at it and which ones aren't. What's very interesting is that about 25% of large litigations today use predictive analysis. And at some point, and maybe Amy will tell us when, there's going to be a switch that will flip, and it will go to 99 or 100%. And that's the first place I want to pause and say, think about what that means to what lawyers do. Because in the old days, you had 100 lawyers, contract lawyers, employed lawyers, going through documents to decide what was privileged, what wasn't. Now, if you have a good technology, a small group of experts and a couple of lawyers, 5 people can do the same thing with algorithms and get more accurate outcomes if they're using good tools. And finally, and I'm going to give a specific example, is contract analysis. JP Morgan, this was published last year, JP Morgan in-house created an algorithm that they called COIN. I don't remember what it stands for, but it must have something to do with the fact they're a bank. But what it did was, It was designed to do contract analysis among 12,000 standardized contracts that they thought were standardized or were supposed to be standardized across the bank. Once they created the platform, they ran the computer for 2 days, and they got the exact analysis that they wanted. And the significance of that is that they calculated, based on prior efforts to do similar kinds of comparison, that job that the computer and the software took 2 days to do would have consumed 360,000 hours of lawyer time and taken a year to complete.
So what do you see for the law firm of the future? What is all this going to do?
I think it means 3 things. First of all, I want to go back to what Nicolas said. The one thing lawyers have that none of the platforms have are 4 human qualities. I use slightly different words, but I go where you were going. Creativity, judgment, empathy, and adaptability. And lawyers are going to be the last mile. They're going to be, okay, here's what the analytics give us, now what do we advise the client to do? So there is going to be a role for lawyers. The idea that robots are going to take over, not yet. Secondly, based on what I just told you about discovery and about document analysis, AI is like a giant Earth-sized sponge. It is going to suck the work that used to be done by junior employed lawyers simply out of existence.
And what's it going to do to law schools, which do not teach any of those characteristics you just described?
I'm happy to go there with you later, but let's stick to your first question. What does it do to law firms? I think law schools have a big problem, but let's come back to that. I think what it does is it totally changes the shape of law firms. We've grown up, you and I, in a world of pyramids or diamonds. Future law firms are going to be flat. Very senior, skilled lawyers, not necessarily in age, but people who have those capabilities of going the last mile, who understand the relationship between technology and client problems, and another layer of people learning the process. But it means something very different. It goes back to law schools. It means the law firms are going to hire not 10 people in the hope of having one left at the end of 10 years. They're going to hire one person whom they want to keep and train consistently and continuously until they're up at the top level. So I think firms are going to be smaller, more specialized, and they're going to have a flat format. And of course, by sucking out leverage, the whole billing model, the whole fee arrangement between law firm and client is going to change. The hourly fee, we've been predicting its end for a long time. AI spells the end of hourly billing.
And maybe a lot of law schools as well.
And maybe, I saw a study last week in the ABA journal, and they tried to put a gloss on it. They said 50% of graduates from 2 years ago were happy with their law degree. I read it the other way around. That meant 50% of recent graduates are very unhappy that they went to law school.
Now, Amy, you're also a real person in a real law firm. What are you folks doing?
Well, occasionally they call me a real person. I have a tad bit of a different take, though. I come from the world of cybersecurity. I'm a cybersecurity lawyer. I'm a technologist. I spent 10 years as a technologist before I became a lawyer. In the world of machines, I'm going to take a motto from DHS, trust but verify. We've learned on the cybersecurity side of the coin, that there has been considerable automation of cybersecurity in the past 10 years. However, the individuals who understand the depth and breadth of what the tools are actually doing are very few. So I wouldn't say that lawyers are always going to be the last mile. There's 3 pieces of the equation, unfortunately, in the legal work ahead and how we're going to be flipping the work ahead. Lawyers are the very first mile. When you have an algorithmic program that is going to be making decisions substantively regarding your case, or perhaps substantively regarding the business decisions that your clients rely upon, you are going to due diligence that tool and understand the workings, hopefully, of that tool in a much more intensive way than if there is far more human interaction. So You want to make sure that the due diligence that you do at the very beginning is extremely robust and complete. And I'm going to add this caveat: to the extent that those using the AI tools and developing the AI tools and platforms permit that due diligence, and that will probably be a contentious nab and grab session between us in a bit. Lawyers are also going to be the internal validators. For those of you who use an AI tool and kind of set it off on your case, you do so at your own peril. Coming from a math and science background, algorithms can fail, programs can break. You do want, algorithmic validation of the substantive decisions that your AI tool is making, or at least an assurance that your tool is indeed working properly. And then I do indeed believe that lawyers will be the last mile as well. In addition to predicting the doom and gloom of the legal practice with AI and how many jobs we could all lose, consider the upswing. Lawyers are going to be responsible for deeper and more complex thinking because of the vast data sets that we're going to be able to analyze and the depth of the issues that we are going to be able to consider. Just to give you an information security analog, log reviews, the traffic that is coming off of, one's firewall or various different appliances. You used to never be able to keep up with a log review or really even detect anomalies 10 years ago. Now we have anomaly detection tools, we have bad IP detection tools, we have tools that help us in the cybersecurity industry develop real-time intelligence and try to sense when there is a bad guy stepping into your network or trying to exfiltrate data from your network. As an industry, we're just learning how those tools are helping us really do a far better job of understanding the threat actor model. What we're about to step in is a revolution of our own analytical model, which I find, fearful as well as everyone in the room, but thrilling. This is the technology change that is going to impact our age. Much like, and not as revolutionary as in the 1970s when, those were, undergoing a complete civil revolution, but much like we are going to be able to really kind of understand and unpack the data that we are looking at.
All right. Judge, we've heard from two distinguished and avant-garde practitioners. What do you see in the courthouse?
I want to talk about two things. One is that it's not transparent to the judge what tools the lawyers are using. So we cannot assess, the quality of the work that they're doing in terms of, are they using the right tools? Do they have the right research and that kind of thing? But what goes around comes around, as the old saying is. You know about the judge because you can input the name and get all the information. The judges can do the same thing about you. And that's not uncommon for the judge, if they do not know a lawyer who is appearing before them for the first time, to find out some things about the lawyer and the lawyer's background. Those tools are being used by the court. Internally, we use the same kinds of research tools that you're doing. We're generally somewhat behind the time. We're a little slower to get up to speed. We don't spend the money as quickly to implement different things, but we're making progress along those ways. The second thing is it's a leveling between the small firm and the large firm. So the quality of work that I'm seeing today from a solo practitioner or a small firm practitioner can be equally as good, if not better, than a large firm because of these tools. That wasn't the case when I started to practice, where you needed to have a large library accessible with all these books, be able to spend hours in them, and small firms didn't have that, so the quality of the research was generally not as good. That's no longer the case today. So I think we'll probably have very large firms. I think there's still going to be a need for that, but there'll be a lot more smaller firms, very boutique, and they'll be extremely competitive because they have those tools and they can be equally as prepared as the other side.
What about these fights that are undoubtedly going to materialize of two good firms or two good lawyers are presenting AI-based information to you? Where are your tools?
Where are my tools? My tools are, twofold. One, you have to depend on the lawyers to be able to present the debate and the dispute in an understandable fashion. So think about the kindergartner and you want to educate the judge, and you have to know your judge. Some judges are more technologically savvy than others, so know the judge, make the presentation understandable. And the second tool that the judge has, and they're being used around the country, particularly in patent cases, is to get a technical advisor. Because if I can't understand that, I need somebody that I can bounce ideas off of and talk to, and then the court will order that a technical advisor be appointed to assist the judge. So those are some of the tools that we have.
You think that second tool would be used? I mean, judges have had the power to have court-appointed experts forever.
It is used in the patent arena, or complex antitrust cases. I've had technical advisors in that case. I had a complex issue involving some chemistry with cans, and what it means to have these trade secrets and that kind of thing. And so I asked for a technical advisor, and they gave me a wonderful retired professor of chemistry, who came and assisted me, and it was very helpful.
Julie, we've had three impressive presenters, plus Nicolas. Two great lawyers who can see the rest of the 21st century, and a judge who has the understanding to know when she needs help, in a sense. I saw that way back in the early days of fighting about copyrightability of computer programs, and I watched two of my great Harvard colleagues who became federal judges, Bob Keaton and then Steve Breyer. They learned computer science. Now, not every lawyer and not every judge in this country will be of this caliber, quality, etc., etc. Will anyone care?
Oh, I think that lawyers will need to care for a couple of reasons. As an in-house counsel, which is my current role, we have to think about the ethical rules of competence just like outside counsel does, and we have an obligation under ABA Rule 1.1, Comment 8, to stay abreast of the risks and benefits of technology. We have corporate clients who are driving toward the use of AI as fast as they can to try to bring down costs and to use their creativity to generate revenues. So we need to stay abreast, and we need to reach out to law firms who are at the front edge and can teach us to be better at dealing with these issues, and the law firms that can't teach us will be left behind. So we will be driving the law firms forward, I believe, from an in-house view. The other issue is, if you look back at the case law, and we have a fun case that many of us studied in law school, the T.J. Hooper case, and it really dealt directly with the question of, if technology is available, would it be negligent not to use it? And that case involved two tugboats that were hauling barges full of coal up the East Coast, and they ran into a storm, and a couple of barges sank with their cargo. No people were hurt, thankfully. And it was clear that once the storm hit, the captains of the tugs did exactly everything they should do to maximize the protection of the cargo and the people. The question was, if they had had radios on board, and there were radios on some tugs at the time, some owners installed radios, most probably did not at that time. If these tugs had had radios, would they have known about the storm earlier And therefore, was it negligent not to have radios? And the courts concluded yes. And on appeal, Justice Leonard Hand even said that there are some precautions so imperative that even their universal disregard will not excuse their omission. So presumably he was thinking about what might have happened if people had been hurt. But the driving force there from the case and its appeal is the technology is there. You are at your peril if you don't use it.
One thing I found interesting is I read the lower court opinions, so I'm a district judge. I like to see what the district judge had to say, and I think Learned Hand followed basically the analysis that the district judge undertook. But the technology was affordable. So it was accessible and affordable. And I think we can't forget that because we're talking about artificial intelligence. We're just at the beginning boom of this. And until some of the pricing comes down, I'm not sure we can impose that kind of burden. And I think that was one telling thing from the opinion that I wanted everyone to pay attention to.
If I'd like to ask Amy a question, because when we were having lunch beforehand, you made, I think, a very important point. I think Nicolas would agree with this. All AI is not created equal. And some of it has been very carefully tested and verified, and some of it's just somebody with a computer writing an algorithm and putting it out there. And part of the problem is, by the time of that decision, radio was an understood technology. Where does the burden lie now, and what's the problem with the unevenness of the platforms?
Oh, absolutely, and I think I might be getting boxed into a corner with regard to this, too. So some individuals would view AI to be predictive coding, and predictive coding analysis has been along for quite some time. And you know, the form of using linguistics and keywords in order to recognize language patterns within a document is something that all of the e-discovery folks in the room would immediately shoot their hands in and say that that is an affordable, defensible technology. Now, the ability to have distributed computing processing power and depending on how the algorithms are put together, and the processing power that you have and the sophistication of the algorithms that you're using, that is where you have more expensive tools. And also, what we're all kind of talking about and dancing around, a greater lawyer competency obligation. So for all of us in the room, I'm going to use an information security analog just because that's kind of my daily bread. But you have a lot of information security lawyers that can opine about the various data breach laws. You have very few information security lawyers who can actually talk with the technologists and help you resolve your security problem. So you have that cross-legal technical functionality. As law firms are trying to determine staffing, as we are evaluating AI solutions, we're not only going to be thinking about technologies and costs, we're going to be thinking of, do we have the right people? Do we have the right competent lawyers sitting in their chairs to understand if the algorithms and the linguistics techniques that we're using and the searching that we're using is really adequate for our case at hand, for our client's substantive issue, or for the driving decision that this algorithm is going to make that you're a regulatory lawyer for. Because we will not only see AI technology tools that are going to replace legal work, our clients are going to be using and are currently using AI tools to replace human decision-making, driving in cars, medical-related decisions that even regulatory lawyers are going to be passing on and debating for quite some time.
See, I was delighted when I heard the good judge talk about the equalization of quality brought about, at least in part, by the availability of Westlaw and Lexis and its basic affordability. But now I'm hearing that we're going to go through a period in which there won't be equalization of access because of cost factors. There will not be equalization of competence. I almost have this wonderful image that every one of the law schools that Anthony closed down will reopen and specialize in AI malpractice.
I don't know that they're going to do that, Arthur, but it goes back to your question. How can you give, in this new world, a meaningful law degree to people who have no ability to do what Amy is talking about, which is understand the technology and make the creative and judgmental decisions? This one's better for my client than that one.
All right, so you're going to put me out of the classroom because I'm not competent. It's a good thing I'm not looking for my next job.
No, but I think the balance of what useful graduates are going to need is totally different from what the law schools are giving them.
I agree. Now, Nicolas, your co-panelists have described a wonderful new world of increased and changed capacity and competences. Is it as simple as that?
It probably isn't. There are, and I don't think they made it sound simpler than it is, but I think there are a couple of interesting ethical questions or areas that are worth thinking about. And the way I like to think about those, and some of them go to competence as well, which is a critical and often overlooked domain, is really think about those ethical challenges, those challenges that are entirely novel because of AI, as opposed to those that are simply amplified by AI. And I think in those that are really novel, there are two, and I'll mention them quickly. I think one is what one might call social AI. Your other technologies don't interact with you, and you don't interact with them, sort of behaving as a human. There are a number of studies in psychology that show that people interact with machines who speak to them the way they interact with people. That raises huge questions about the sorts of toys you can entrust to kids, how they get influenced in their values, their political beliefs, etc., and all the way through your life, to elder care, etc. So that's one, I think, really novel issue. The other one, and the crucial one, and we'll talk about what that implies in terms of the normative governance that, of AI, is that what we don't do with other technologies that we do with AI is surrender human agency to non-ethical agents, right? And when I say non-ethical, I don't mean unethical. I just mean machines that are not capable of making some of the very complex decisions that require us to balance different values and different interests, the way judges do every day in court, right? Machines can't do that. And agency, how we make decisions, how we struggle with the values we've been taught, how we balance interests, agency is at the heart of any conversation of ethics. And therefore, if we surrender human agency to machines, that raises a huge number of questions, right? We have thousands of years of experience governing HI, human intelligence, as reflected in our norms, our laws, our regulations, our codes of ethics, and so on. None of that with respect to AI, and there is foundational work to be done. Very quickly, so these, I think, are the two key novel challenges, social AI and the transfer of agency to machines. I think two that are amplified significantly by AI, but are existing challenges. I'll go very quickly through those. One is the ability of government to sort of know everything about you. It's sort of the panopticon thing, right? The central entity being able to know, observe everyone at all times. One has to wonder, are the protections we have in place sufficient? Is the Fourth Amendment, and I speak as a citizen, I'm not an attorney, is the Fourth Amendment sufficient to protect us when we're not that far from moth-sized, drones that could look into your apartment 24 hours a day and listen to what's being said and read what you're reading and so on and so forth. And the second and more interesting challenge, I think, for us as citizens, or that's slightly on the novel side, is not that the central authority can observe all of us, is that we can all observe everyone else, starting with corporations who can know everything about what we do. And I don't mean about the things that are secret and we want to keep private. I mean everything that we do every day that we don't care about individually. If somebody knows I went to a restaurant yesterday, I don't care. But at what point can I be offended and find it intolerable that a company knows everything I read, everywhere I go, who my relationships are, who I call, where I've been, what I've read, what I've bought, and that they can create for me an image of my identity that in fact becomes who I am for society, against which I have no recourse. This is not the 1984 problem. It's sort of the Kafka trial problem, and there's been great scholarship by Soloff on this and others, Ryan Calo, if you read any of those folks. But in effect, you surrender your identity, and I don't know, I finished just with that comment, and again, I speak as a citizen, not an attorney. I'm not an attorney. But we have this third-party doctrine that says if you surrender information to a third party, you have no right to privacy. Today, we need to surrender everything we do. We're putting in the cloud to third parties in order to be able to function as citizens. And can it be the condition of being able to function as a citizen that you surrender any right of privacy, especially when one knows that there is no conception of what it means to be human today for us without dignity. There is no dignity without privacy. And there are many companies today deciding on their own what they are doing with our data, which means with our dignity, our privacy, and our sense of what it means to be human.
Sure.
So I'll leave it at that.
Sure. Nicolas, you're bringing up two very, almost two sides of the same coin. I think the AI debate is an enigma wrapped within privacy and data security. So on the privacy side, there are going to be, I hate almost the image of Big Brother and knowing everything about our own commercial transactions and our being. There are very good minds and associations, admittedly, some that I work for, who are trying to determine at what point is too much information for digital advertising, for individual profiling, but I think it bears noting that marketers have known a significant amount about the consumers that they are attempting to target, even before the digital age. Even when there was targeting by postal zip codes and households, it's not at the level of depth, but in the event that we want to still maintain a consuming society where consumer goods do drive the base sales of our economy, we do have to think through and permit, and the Federal Trade Commission, and when it's Section 5 analysis and state laws are doing this, and think through at what point is how much data is too much. Because, for example, I do not much care if someone knows my preference for Crest versus Colgate. I do care, however, for example, in the Target issue that happened about 8 years ago, whether or not there can be a predictive analysis of whether or not I'm pregnant, whether or not I'm going through a medical issue. So if you look at FTC, Federal Trade Commission, Section 5 precedent, there are certain classes of sensitive data where the consumer, if that information is going to be stored, shared, consumed, analyzed, where the consumer must affirmatively opt in and provide knowing consent. There is existing doctrine for that within the FTC Section 5 precedent and with many sector-specific laws. But what the problem that we're going to have is, I think, twofold. It's not just a privacy problem. It's a data mapping problem, because we are going to have the increased ability for processing of data, but also with the problem that many systems and many data sets are very ill mapped, and people do not understand what is being fed into that very large data lake. So we're going to be dealing with amplified data privacy concerns and amplified corporate due diligence that is necessary in order to feed and understand the information going within your data lake to be processed by your AI tool.
Can I give an example that I came across recently that illustrates what both Nicolas and Amy are talking about? A very dear friend of mine is the chairman of one of the larger European insurance companies, and they sell retail insurance products, home insurance, automobile insurance. And they're now testing AI software. If you go online to their site and say, I bought a new BMW and I want to insure it, what you get back is not an application form, but a price. Because they know everything about you from the big data on the cloud. And of course, the problem is the data accurate? What factors does it take account? Does it just take account our income or the automobile, or does it take account of the fact that the computer thinks we've had 10 accidents when actually it was somebody else? So that's a real life iteration of what both Nicolas and Amy are talking about.
I just wanted to give a quick... Go ahead.
No. Just to tag on the law to that issue, is that insurance company vis-a-vis processing that big data lake and the corporate understanding of your habits and what is available for you publicly, is that insurance company creating a credit report, then creating FCRA and FACRA consent and disclosure obligations. So, one thing I think we want you guys to walk out of here knowing is that AI is not the wild, wild west where there is no existing law to guide the consent and disclosure structure. U.S. state-specific and federal sector-specific privacy obligations are still going to govern the consent and disclosure of the process, use, handling, storage, and security of that data. And my apologies, Nicolas, for jumping over you.
No, sure. The only comment I wanted to make was on this notion of consent, of opt-ins. And so there is a statistic which says that each of us signs about 10 new consent forms a week or a month, is it? Because we use new services. They're typically cloud services. So two issues with those. One is we don't have the option not to sign those if we want to function as a member of society. So I don't believe that our opt-in reflects a free choice. It reflects a complete loss of agency. You don't have the choice to not do that. The second thing is, is that all of those privacy consents you sign, all of them say how much these companies care about your privacy, and in the fine print say that they can do anything they want with it. An interesting quick anecdote is when the Equifax breach happened, was one of the folks who went to sign up for the credit monitoring service. So you were directed at the company that you weren't told they owned. And if you look at the privacy policy that you signed in order to be able to now protect your credit from monitoring, it effectively said that it cared enormously about your privacy, but that it could do a ton of things obviously with your data, and also said that in case of asset sales, they could transfer your data. And given that your data is the principal asset of companies like that, they can sell your assets, in effect, perfectly legitimately, and you probably have trouble challenging it. So the question there is whether I think legal doctrine and how we're thinking as a society of the amplification of those challenges, where simply we don't have the cognitive ability to understand the commitments we make, we cannot realistically opt out of those things. If the legal doctrine we have in environment is actually sufficient to meet the needs that we have as citizens and to protect us as citizens. And again, I come back to this notion of privacy, which is a necessary part of dignity and itself of the human experience that we want to have, I think, in our societies.
Not only don't we have the knowledge, we don't have the bargaining power.
Absolutely.
Yeah, absolutely. And I'm certainly not going to be one here to try to defeat the notice and choice consent metric that we've used for the past, for the years that we've been doing privacy doctrine. But there are fundamental flaws in notice and choice consent. I think AI is going to amplify, the flaws in that pattern, but also it's going to necessitate, digital literacy and digital education for both consumers and also the companies that you're working with. Just to give you an example from the advertising industry, there are a significant amount of consumers by virtue of privacy backlash and digital ad functionality that are choosing to install ad blockers. And Fortune 500 companies that engage in digital advertising have the Better Ads campaign and a campaign called TAG, the Transparency and Accountability Association and Group, in order to improve privacy standards, improve disclosures, and improve functionality of ads because the market is speaking. So, I don't think that we're within a time in which notice and choice will never be functioning. I think it's part of the privacy framework and part of the U.S. sector-specific law that it's been evolving for decades, and that process will simply evolve. privacy policies as we know it are going to evolve, become easier, become shorter, perhaps be nutrition labels, as as some academics have proposed. But
I feel like Yogi Berra. For me, this is deja vu all over again. Close to 50 years ago, before just about everybody in this room was born, I helped draft the Educational Privacy Act, the Fair Credit Reporting Act, the Information Privacy Act that applies to the federal government. Every one of these points was made. That debate is no different today than it was 50 years ago. What's changed is scale and speed. The notion of informed consent is something only lawyers could create. It is non-existent. The notion that we're going to have a population of specialists on digital privacy, tell that to the 15 or 20 million Americans for whom English is not a native language. I mean, it's pie in the sky. You have to go back to Nicolas when he speaks as a citizen, not a lawyer. The fact that you have clients in the corporate, industrial, marketing world, should they be making decisions about my privacy? I don't know. Julie, you work in the corporate world. Are you taking care of me? The dumb American, the old American who doesn't even want mail order stuff?
Well, it's hard as in-house counsel to have your clients do more than what the current law is requiring, so that tends to be our touchstone. But I was going to bring up the GDPR, right? In the EU, the framework is different, the thinking is different, the form of notice is different, and the expectations are different, and there may be, if we don't build border walls that are too high, there may be seepage our way of some of those ideas. And there may be I think there are other ethical challenges and ethical groups, I might pass it back to Nicolas, who are thinking about how to deal with these issues, because I don't think it's going to come from in-house counsel. I think
Give me
it's going
some
to come
principles,
from society.
Nicolas. Give me some principles.
I'll be happy to tell you what.
Let me sleep easily at night.
So there's a slide you can look at with, I think, what the collective wisdom is amounting to. The main question here is to really understand there are foundational questions of how, again, we answer this question in a normative way, which is, how should society delegate to machines decisions that affect people, right? And again, we have norms of governance of HI, but not of AI, and it's time to think of that. So there are a few really interesting entities that think about this these days. The UN is thinking about that. They have an AI for Good initiative. The IEEE, which is sort of the Brotherhood of Engineers around the world, 400,000 members. It's a standard-setting body, has developed an initiative called the Global Initiative for Ethical Consideration in Autonomous Systems, and they have specifically sort of an ethics sort of committee thinking that. The Future Society, of which I'm part, has been doing very nice work in this domain, thinking about what norms, what guidelines, what ethical principles should guide the adoption of AI, and some of those are up there. And there's maybe just a couple that are worth sort of mentioning. We have no time for all of those, but one that's really important is competence. And we talk a lot about the competencies that attorneys must have to handle technology. But I'll use an analogy. I'll say, we all are willing to surrender our bodies to sort of a scalpel-wielding human, but the only reason we do that is because society has defined very clear norms as to the competencies, credentials, academic education, training, such a scalpel-wielding human must have, right? In AI, we don't have that. So lawyers who use AI have the, so to speak, the competence of their own competence. They decide if they're competent. That's true for judges, it's true for so many people. And so there is a real question as to what competence means. And the studies we have, the NIST studies, the TREC studies, I think they suggest that to combine HI and AI with efficacy in a way that is replicable, teachable, that society can rely on. Combining AI with HI is a science, and very often I would say that when a judge, and we have a case, Loomis case we'll touch on in a minute maybe, where a judge trying to really look at all the information possible and to make complex judgments uses AI in his or her judgment, or where an attorney combines HI with AI, they view this as either practicing law or judicial expertise, but I think it's really practicing science without a license. And there is a real question as to what competencies one should have. And I think there are more scientific competencies than legal competencies, even though the combination of that you want of AI and HI is to the service of legal tasks. I should probably
Let Julie tell us about the Loomis case.
I will. Before I do that, I want to bring up the measurement, because as an in-house counsel, my lawyers always tell me, the outside counsel always tells me that they know how to guide me in a particular area, or that they know what they're doing with the technology. But before I let them give me good advice, or before I let them go into court and make representations on my behalf, which may get us in trouble under Rule 3.3, candor to the court, 3.4, fairness to the opposing counsel, I want to know that it's actually working, what's actually happening, and what representations we're going to be making. And so I would add, in terms of high level of importance, the measurement of what the artificial intelligence has actually produced, so that I can evaluate what kind of representations we'll be making. With respect to the Loomis case, which you asked me for, Loomis is a criminal case where Loomis, who pled guilty to a couple of criminal charges, was sentenced, and he appealed the sentence as a violation of his due process rights, because the sentencing court looked at statistics on recidivism that were purportedly based on people like him, and the algorithm that ran those statistics and created nice bar charts that showed likelihood of violent recidivism, for example. The algorithm was proprietary. It was a black box. There was no information available to him as a defendant in terms of what information was fed in to that system, or how it valued the factors, weighed the different factors that were fed in, or how it scored the results. So he said, black box, lack of due process. I can't interrogate what happened. And there were some studies out suggesting bias in these types of algorithms. Bottom line, the Supreme Court of Wisconsin in this case, which took questions up on certified questions on appeal, said because the sentencing court only considered the algorithm results, but it didn't rely on the algorithm results exclusively, it was okay and not a violation of his due process. They did say in the future, if a sentencing memo has these kinds of statistics in it, it must also be accompanied by warnings that explain some of the limitations, but we could debate whether warnings work. And the kinds of warnings were about the lack of knowledge of the factors that went into the algorithm and fed out the results.
So, Judge, how do you react without asking you to criticize the Wisconsin Supreme Court?
Well, it's really the beginnings of the Minority Report effect on criminal law, because these are predictive tools. The tool is telling you if it's a pretrial situation and the question to the judge is, should this person be released, even though they've just been accused and not convicted, should they be detained and stay in jail while they're awaiting their trial? And then if they're convicted, the question is, what kind of restrictions should you put on them after they serve their time in jail? So this is a predictive tool. It's just like in the Minority Report where they were saying, this person is about to commit a crime. We're going to go and stop it from happening. And so the judges asked, can we stop this? Should we stop this person from being in society, because we're concerned that there's a high risk that they are going to commit a crime of violence, because that's what you're looking for, or drug trafficking, engage in drug trafficking, which is akin to a crime of violence in terms of being a danger to the community. That's what you're looking at. danger to the community. So today in the federal system, we don't use these tools for sentencing. The judge is not even aware of the outcome of the risk assessment that is performed by the probation officer. The probation officer keeps that to himself or herself, but they use it in advising the judge. But the defendant doesn't see it, the judge doesn't see it, and we're very cautious about that in the federal system. But still, it is the predictive tool that is being used today in the federal system by our pretrial and probation officer. So it has some ominous consequences to the person who is the subject of the assessment, and it's very hard to challenge it because no one knows what the tool is. But it's like in the Wisconsin situation, it's not determinative. It's not the final thing. You still have the judge sitting there that can look at the person in the eye, can hear from the family, hear from other factors about the individual, and actually read the background and make a different kind of assessment that's not just a prediction that's in the black box.
Do you have a reaction to the notice aspect of the Wisconsin Supreme Court? Just tell the reader it's worthless.
What they're saying is, we can't trust the tool because it's not been tested. We don't know what's in the tool. It could be biased, so if the person that's involved is African American, it could be weighed against that person. So if you're the judge and you're hearing this, you'd say, what good is this? I'm just going to go back and use my own tool. But we're all human beings, so once that number's in your mind that's saying, gee, this person, if I let them out, they could harm somebody. So, do I want to take that risk as the judge? Am I better than the machine? So, those are the dilemmas you have as the judge.
I just want a quick addition to this. So one is, that case is very interesting because it raises all these questions of norms. How should courts actually adopt AI? We ask judges to make incredibly difficult decisions, balancing different values, different interests. And it makes absolute sense to say, here is something that science and technology can give you. But at that point, we are actually surrendering some agency to machines. And the question is, how does a judge know, how does society know that AI works? And it turns out in the civil justice system, we have at least one good example of that, which is, all of you know those metrics, the precision and recall metrics, which can very simply be interpreted by a judge or litigants without having to look at all the intricacies of an algorithm, where all of us can know that 70% accuracy is better than 50. It's something that preserves our agency. We can understand what it means very concretely, so can courts. In the Loomis case, this algorithm was a black box. It was not measured. Nobody knew if it works. And nobody can rely on it. And to the last point you made, Judge, there is actually a well-known sort of effect called anchoring in behavioral finance, which means that once you have seen something that was relevant information to you and it anchors your initial thinking, it is incredibly difficult to escape from it. And so we can't pretend that these psychological sort of impacts don't exist on judges, no matter how much they're trying to be impartial and to carefully consider all aspects. So it goes back to the question of the normative aspects of the governance of AI, and that's why the work the IEEE is doing, the Future Society is doing, and I know actually the Center for Civil Justice at NYU is getting involved in that discussion as well, which is what are the norms that will guide over time the codes of practice, the way in which we as society will govern AI.
Of course, this can show up in civil litigation, too. The Supreme Court has recently signaled that it might be willing to accept some statistical data. Well, statistical data is an inch or two away from AI data. Anthony?
I just wanted to go back to something Nicolas said, and you used a big word earlier, malpractice.
Me?
Yes, you raised malpractice, and Nicolas talked about competence. I think there are two malpractice issues that lawyers need to think about. Number one, there is a case about to go to trial against at least one, if not two, very large national firms for not being competent, committing malpractice in the use of electronic discovery data. But that in itself leads to a second question. If you're using an AI tool And very few AI tools claim to be 100% accurate in what they do. And there's a mistake made. Where's the allocation of risk? Who should actually be sued? The AI developer or the law firm? But the point is, these cases are actually already starting. The question of what is competence and who's to blame is already starting to surface.
Exactly, and the best practices standards, in addition to being developed by academia, there is the Partnership for AI, that is a trade association of Google, Microsoft, IBM, many of the platform developers that have developed 7 tenets. The very first being in the event that AI has a criticality, a safety of life, safety issue, that must have transparency. But then even for civil applications, even for normal business decision making, you have to have an accountability element, because in addition to items ending up before a courtroom, simply decisions that could discriminate or have the effect of discriminating on protected classes are also decisions that we care about and may ultimately appear before a courtroom. So civil society is trying to understand AI. Business is trying to understand AI, and I must admit I'm going to jostle with Arthur Miller. And I think society is jostling with AI and privacy and security, that we do have to, as lawyers and as citizens, become far more digitally literate if we want to remain within the 21st century economy.
Judge?
I can see the bar putting forth proposals to have some kind of standardization so that you have some standards, and if it meets a certain standard, if you as the lawyer use it, there'll be a safe harbor. So that's my prediction for today, to look forward to that down the road.
Okay, as in Shakespeare, the highest ranking person left alive at the end of the play speaks last, and that's the judge. Our time is up. My thanks to the panel.